Freemen on the Land are a loose group of individuals who believe in a conspiracy theory that they are bound by statute laws only if they consent to those laws. They believe that they can therefore declare themselves independent of the government and the rule of law, holding that the only true law is their own interpretation of common law. Freemen are active in English-speaking countries, the United Kingdom, Ireland, Canada, the United States, Australia, and New Zealand. In the Canadian court case Meads v. Meads, Alberta Court of Queen's Bench Associate Chief Justice John D. Rook used the phrase organized pseudo-legal commercial arguments, OCA, to describe the techniques and arguments used by freemen in court, describing them as frivolous and vexatious. There is no recorded instance of freemen tactics being upheld in a court of law. In refuting one by one each of the arguments used by Meads, Rook concluded that a decade of reported cases, many of which he refers to in his ruling, have failed to prove a single concept advanced by OPCA litigants. Freemen on the Land are also called Freemen of the Land and the Freemen movement. They may be an offshoot of the sovereign citizen movement. The Federal Bureau of Investigation (FBI) classifies sovereign citizen extremists as domestic terrorists, and states that these groups may refer to themselves as freemen. Freemen believe that statute law is a contract, and that individuals can therefore opt out of statute law, choosing instead to live under what they call common, case, and natural laws. Under their theory, natural laws require only that individuals do not harm others, do not damage the property of others, and do not use fraud or mischief in contracts. They say that all people have two parts to their existence, their body and their legal person. The latter is represented by the individual's birth certificate. Some freemen claim that it is entirely limited to the birth certificate. Under this theory, a strawman is created when a birth certificate is issued, and this strawman is the entity who is subject to statutory law. The physical self is referred to by a slightly different name, for example John of the family Smith, as opposed to John Smith. Many freemen beliefs are based on idiosyncratic interpretations of admiralty or maritime law, which the freemen claim governs the commercial world. These beliefs stem from fringe interpretations of various nautical-sounding words, such as ownership, citizenship, dock, or birth certificate. Freemen refer to the court as a ship, the court's occupants as passengers, and may claim that those leaving are men overboard. Freemen will try to claim common law as opposed to admiralty law jurisdiction by asking, "Do you have a claim against me?" This, they contend, removes their consent to be governed by admiralty law and turns the court into a common law court, so that proceedings would have to go forward according to their version of common law. This procedure has never been successfully used. Freemen often will not accept legal representation. They believe that to do so would mean contracting with the state. They believe that the United Kingdom and Canada are now operating in bankruptcy and are therefore under admiralty law. They believe that since the abolition of the gold standard, UK currency is backed not by gold but by the people or the legal fiction of their persons. They describe persons as creditors of the UK corporation. Therefore, a court is a place of business, and a summons is an invitation to discuss the matter at hand, with no powers to require attendance or compliance. They may believe that the government controls secret bank accounts in their name as part of this theory, which may be accessed to pay off debts. None of the beliefs held by freemen have ever been supported by any judgments or verdicts in any criminal or civil court cases anywhere. An English solicitor, writing anonymously, commented, "Strategy might give lenders pause, of course, because litigating against awkward characters isn't much fun. But given how flimsy the freemen legal arguments are, the pause needn't be long." I've seen a transcript of a hearing in which a debtor tried to rely on the freeman defense. It was over as soon as the judge asked, "I can imagine the withering tone, are you planning to persist in this defense, Mr. Jones?" Freemen believe that since they exist in a common law jurisdiction where equality is paramount and mandatory, the people in the government and courts are not above the law, and that government and court personnel therefore must obtain the consent of the governed. Freemen believe that those government employees who do not obtain consent of the governed have abandoned the rule of law. They believe this consent is routinely secured by way of people submitting applications and through acts of registration. They believe the public servants have deceived the population into abandoning their status as freemen in exchange for the status of a child of the province or ward of the state, allowing those children to collect benefits such as welfare, unemployment insurance, and pension plans or old age security. Freemen believe that the government has to establish joinder to link oneself and one's legal person. If one is asked whether one is John Smith and one says that is so, one has established joinder and connected the physical and human persons. The next step is to obtain consent. Statutes are merely invitations to enter a contract, and are only legally enforceable if one enters into the contract consensually. Otherwise, statute laws are not applicable. Freemen believe that the government is constantly trying to trick people into entering into a contract with them, so they often return bills, notices, summons and so on with the message "no contract, return to sender." A notice of understanding and intent and claim of right is a document used by freemen to declare their sovereignty. The signed document, often notarized, is sent to the Queen and possibly other authorities such as the Prime Minister and police chiefs. It usually begins with the words "whereas it is my understanding" and goes on to state their understanding of the law and their lack of consent to it. The British publication Benchmark has asserted that freemen's beliefs are based on misunderstandings and wishful thinking and have not been successful in any courts anywhere.